You worked your whole life, saved a portion of every paycheck, so that one day you can retire and live out the rest of your days as you see fit. A divorce can put all your big retirement plans into jeopardy. I'm Jenny Bradley, owner of Triangle Smart Divorce in Cary, North Carolina. When clients come to us, either when ending a relationship or starting a new one, retirement accounts are one of the most important assets to protect, particularly since for most people, it's their largest asset. Unfortunately, retirement is one of the most complicated assets to deal with in a divorce. I'm going to give you a very brief summary at the 10,000 foot level about how different retirement accounts are divided during a divorce. Of course, there are nuances to everyone's financial situation, which makes it important to work with an experienced divorce attorney, especially when you have a significant amount in retirement accounts and you want to keep as much of it as possible. Let's start with the easiest and most popular retirement account, IRAs. The rules for dividing IRAs are pretty straightforward. If you put the money in the IRA before marriage, that money is yours, and any passive gain on that premarital money is yours too. Passive gain means market changes up or down. However, any contributions into that IRA after marriage and the gains on those contributions are marital property and are subject to equitable distribution. There are a few things that you may inadvertently do, though, which can make that premarital property turn into marital property, like commingling marital and premarital assets so much that you can't tell which is which anymore, or actively managing your premarital funds using marital time and talent to grow them. Whether something is marital property or not is more complicated than it initially sounds. In North Carolina, you cannot divide IRA money until you're divorced. Either your separation agreement or your court order will dictate if and how your IRA should be divided. Your financial institute will help you start a rollover to shift IRA funds to your ex-spouse. Warning, if you do this transfer wrong, you risk penalties and taxes. If you do not trust your spouse to manage the portion of the IRA you're getting while you're separated, you should seek the right to separate your share within the account and ask to be allowed to manage it as you see fit until you're divorced. Otherwise, you are left to the investment choices of your soon-to-be ex, which may or may not be a good idea. Now, let's move on to 401ks. Like IRAs, 401k funds obtained during the marriage are treated as marital property and subject to equitable distribution, as are the passive gains on the marital portion. But if you had a 401k before marriage and then continued contributing after marriage, the situation is just as sticky as figuring out the separate portion of a combined IRA. Once you gather all the documents and do the math to figure out what is marital and what is separate, then you can either agree to the amount to be divided by private agreement or by consent order. And if you don't agree, then the court will sort it out for you, with the presumption being that it's all marital unless you can show otherwise. Regardless of if your 401k is all marital or is part marital and part separate, you will need a qualified domestic relations order, or QDRO, to divide the 401k. The QDRO is sent to the plan administrator to review, approve, and implement. Pensions are similar to 401ks in that you need a QDRO to disperse funds. They are different than 401ks in that we typically use a formula called the Coverture fraction to figure out the percentage of the account that is considered marital property. That's a fancy way to say we take the number of months married while on the job and divide by the total months on the job until retirement to get a fraction. Then that fraction is applied to the benefit amount at the time of retirement to calculate the marital portion. Once again, a QDRO is the legal document that instructs the plan administrator on how to divide the pension. And take note, both vested and unvested pensions are subject to equitable distribution in North Carolina. Another way to address a pension is to have the present value of the pension calculated and offer a lump sum payment to buy out the other spouse, or to offset the present value of the pension against other assets. Present value takes several things into account that are educated guesses, if you ask me. Like, when will you retire? How long will you live? What interest rate to bring future dollars back to the present value, and any cost of living adjustments for the pension, as well as other factors. For those reasons alone, We do not recommend clients buying their spouse out of the pension. To do this, you typically have to give up more of another asset, such as a savings account, a house, a car, anything of similar value. What if your employer converts your pension to a hybrid plan, like we saw IBM do years ago, and devalues your pension? Or what if your plan goes bankrupt, like happened at Nortel and American Airlines? We've watched too many pensions go bankrupt, giving you pennies on the dollar what you thought you were getting. You end up in a bad deal if you traded the house for your now bankrupt pension, and there's not a thing you can do about it afterwards. We know there are a lot of state and federal non-military employees in our area, and just to let you know, there aren't many differences on how federal and state pensions are handled. Pretty much, they'll be treated the same as private pensions for division purposes. On the other hand, military pensions are not going to follow the same rules. For a non-military spouse to be eligible for pension payments after a divorce, they must have been married to their spouse for at least 10 years, and at least 10 years of the marriage had to overlap with the military service. We call this the 10-10 rule. If the 10-10 rule is applicable, then you are entitled to a portion of the pension payments upon the military spouse's retirement. We use that Coverture fraction here as well to figure out the portion of the benefit if the military service is longer than the marriage. So what happens if you don't have 10 years of marriage overlapping with 10 years of military service? Not all hope is lost. You may be able to receive a portion of these payments as alimony if your spouse is already retired, or you may be able to come to an agreement with your ex for them to send a portion of the retirement benefit to you. I just plowed a lot of ground on this video, and if it sounds complicated, it's because it is. If you take one thing away from this video, let it be this: hire an experienced divorce attorney to handle the division of retirement accounts. And now, as a special bonus to you for sticking around to the end of the video, here's one more tip. Change your beneficiaries. The last thing you want is your ex-spouse to get a big check after you die. We see and hear about so many people forgetting this step, and we're upset when their children or new spouse, who are the intended beneficiaries, don't get the retirement funds. Beneficiary designations override any will you have in place, and if you don't have a will, beneficiary designations override statutory inheritance rights. You must go to each retirement account and change the beneficiaries. You need to do this with any other assets with beneficiary designations, or transfer on death, or pay on death designations. Maybe you have a life insurance policy or banking account set up this way. It's tedious, but trust me, it's worth it, assuming that you want to control who receives your hard-earned money after you pass away. Retirement accounts can be a headache when going through a divorce. One way to alleviate this is to have a prenup in place before getting married. If you don't have a prenup, finding an experienced family law attorney familiar with the ins and outs of retirement accounts can make the complicated much simpler. We do that for our clients here at Triangle Smart Divorce every day, and we'd be happy to help you as well. As the saying goes, don't try this at home. Give us a call.